The FBI questioned Faisal Shahzad for more than 3 hours before he was read his Miranda rights under a well-established exception to Miranda for immediate threats to public safety. But Attorney General Eric Holder, apparently concerned that investigators may push that exception too far, has now called on Congress to enact a broader exception to Miranda. In our fourth story tonight, would it be another regrettable move to chip away at the Constitution, this one under President Obama? John Dean will join us in a moment. Attorney General Holder did once again defend the criminal justice system's capacity to deal with terrorist suspects, including reading those suspects their Miranda rights. But he thinks Congress should revisit those rights established by the Supreme Court in 1966.
But I think we also want to look and make determinations as to whether or not we have the necessary flexibility, whether we have a system that can deal with the situation that agents now confront. We're now dealing with international terrorism, and if we are going to have a system that is capable of dealing in a public safety context with this new threat, I think we have to give serious consideration to at least modifying that public safety exception. And that's one of the things that I think we're going to be reaching out to Congress to do, to come up with a proposal that is both constitutional, but that is also relevant to our time and the threat that we now face.
No indication that a broader exception to Miranda based on international terrorism would even satisfy those bending the issue for political purposes who do not want terror suspects at all put through our nation's criminal justice system. Rudy Giuliani, for instance, supported Holder's proposal. He said it would still be better to hold suspects like Shahzad as military detainees. Giuliani joins the likes of Senator Lindsey Graham and Senator Joe Lieberman, who have offered various ideas about how to discard Miranda rights in the case of a terror suspect. Let's bring in, as promised, former White House counsel, now columnist for FindLaw.com, John Dean, also the author of Blind Ambition. John, good evening.
Good evening, Keith.
Are we clear yet to any degree what Holder is proposing here? Do you have any idea?
Well, I actually caught the clips and then thought that isn't very clear, so I went back and looked at the entire transcript, and I wasn't clear at first if he was really responding just to leading questions, and or if he'd actually had some proposal that he had in mind at the Justice Department. It appears the latter, although I don't think he was ready to announce it on Sunday, but rather it was forced out because of the questioning.
It would seem as if a public safety exception to Miranda would be enough of a dilution, and we just saw its effectiveness in practical real-time circumstances in New York in the capture and arrest and interrogation of Shahzad. Why would anybody think that's not sufficient?
Well, it's certainly good political grandstanding. The right has been hammering on this, on how tough they are on terrorism, how weak the Democrats are, so they keep pounding that drum. It looks like Mr. Holder and the administration is trying to respond to that. They're never going to satisfy it. In fact, we don't need legislation. There's no evidence that Miranda has ever been a problem for law enforcement. There's no evidence that it's a problem now with terrorism. There's no evidence they need anything more in the exception than they already have.
In 2000, the Supreme Court addressed a Miranda case, or a case that was supposed to essentially overrule Miranda. Can you fill us in on that?
Yeah, that was the first real sort of constitutional test of Miranda. A lot thought, because of some of the earlier opinions he'd written, that Rehnquist would overturn it. It turned out in the Dickinson case there was no such overturning of the based on the statute. Congress had tried to really redefine the whole area of Miranda unsuccessfully. That isn't the case here. There happens to be already an exception that Rehnquist wrote in another opinion later in '84 while he was on the Burger Court, and that's really the prevailing law, and I believe there's ample room within that exception today for terrorist investigations.
It's curious, certainly, the timing of this, that as you suggest, that it would sound like Mr. Holder had an idea but wasn't really ready to announce it, and yet announces that there is an idea the day before a Supreme Court nominee is revealed. Are these things, is it just juxtaposition, or are these things somehow related? Is this going to come up in the Kagan confirmation hearings, and perhaps was it intended to come up in the Kagan confirmation hearings?
I'm sure it's going to come up in the Kagan confirmation hearings. I'm sure she will dodge the question, as all good nominees do. They don't say what they will do or not do when they're on the court. What's interesting, though, is as Solicitor General, while she's still there, she could resolve this problem. There is a split in the circuits. There has been for years. There's a broader interpretation of the exception. There's a very narrow interpretation of the exception. I'm sure there are enough cases that they could pull one up as Solicitor General, and she could litigate this before the court.